Welcome to On the Move.
Jury, please give your attention to Mr. Freeman, who will be giving a closing argument on behalf of the defendant, Mr. Worley. Mr. Freeman.
Good morning. Mr. Worley would also like to thank you for your service. I think it's a shame you have to be here. I think it's a shame that this charge was brought, which is so obvious that all the city is trying to do is limit Second Amendment rights. And it's clear by the evidence that that's what's going on, and it's clear when you look at the evidence and compare it to the jury instructions. It is instruction number 8. The mere open carrying of a semi-automatic rifle in public is not illegal. It's not. So I can take that weapon, I can sling it over my shoulder, and I can walk around town. Unless I do so in a manner, under circumstances, at a time and place that warrants alarm for the safety of other persons. But you can't limit yourself just to that. You've got to look at instruction number 9. Warrants alarm for the safety of others applies only to conduct that poses a threat to others. All he did was carry the firearm. It is not illegal to carry the firearm. There must be some other conduct which establishes a threat to others. And every witness here testified that there was not. Every witness here said, all he did, all I saw him do, was carry the firearm. That's it. If you find him guilty, you're allowing the city to take away Second Amendment rights. We're not saying Second Amendment rights shouldn't be limited. We're not saying that if someone carries a firearm in a manner, under circumstances, and a time and place that warrants alarm for the safety of others, that shouldn't be a crime. That's not what we're saying. You can carry a firearm. That's all he did. So let's talk about the reasonable person standard. What that means is that it's not a subjective thing. It's not enough that the city put up a witness that says, I was alarmed. It's got to be something that is reasonable. Some people can be unreasonable in an emotion. So let's look at the two witnesses that were put up by the city. Miss Pauser, I'm sure she's a nice lady, but you got to question her credibility. She told you at the time that this occurred, she said something to Mr. Worley, that she told him, you should just get your drink and go. That's what she says she said, and you've seen the video. She doesn't do anything like that. She tries to play off what, in the video, it was very clear that she appeared fine. She wouldn't even notice it, as long as you're going to protect us. No, I'm good, as long as everybody else is good, I'm good. It's not until later that she starts to think about things, that she starts to worry about, oh my gosh, what if? And then that what if starts to cause anxiety for her. Remember, she told you she was numb at the time. She wasn't alarmed at the time. She admitted she wasn't. She starts to think about things and then think about stories, and now the police get involved and come question her, and she starts to spin. She starts to get upset. And she might be a little fragile. She might not be the reasonable person. She had chest pains out in the hall, having so much anxiety to come in here and testify. I'm not saying that testifying isn't a stressful event, but she reacted with chest pains. She's not the reasonable person standard, number one. And number two, she wasn't alarmed at the time. She, in retrospect, thinks maybe she could have been or should have been, but she wasn't. And let's look at Mr. O'Brien. Mr. O'Brien tells you specifically, let me grab my, he tells you specifically, that he employed a company policy when he ordered that lockdown. And that company policy was when there could be a possible threat. What he said. I wrote it down. When there could be a possible threat. And then Mr. Randall asked him, you don't wait until there is a threat. He says, no, we don't. Well, the law says that warrants for the safety of others applies only to conduct that poses a threat. That poses a threat. Not that could possibly pose a threat. I'm not critiquing his company's policy. That's fine. That's their policy. But don't mistake it for the law. He didn't see a threat. He didn't say he saw a threat. He said he saw a possible threat. And that's important. I'm not splitting hairs. It's important. Because the city's asking you to find Mr. Worley guilty of a crime because somebody saw what could be a possible threat, even though the law says applies to conduct that poses a threat. Mr. Worley did nothing that poses a threat. So you're going to get an instruction, and the court's already read it to you, but you'll get to read it. And there's an instruction that discusses the difference between direct evidence and circumstantial evidence. And direct evidence is going to be what a witness stands up there and testifies to you. And circumstantial evidence is going to come from the meaning of evidence, kind of. Not what a witness comes up and says, I felt or I did. So I want you to take a look and recall the circumstantial evidence in this case. The video. Mr. Worley's walking around for half an hour, encountering people. And not one of them reacts. Not one of them has alarm. In fact, any reaction was polite curiosity. And they asked him, what are you doing? Why are you doing that? And he explained, oh, I agree with you. Every single interaction was like that. You didn't see anybody go like this. You didn't see anybody veer away from him. You didn't see any of that on the video. That's meaningful. That's important. The city wants to tell you that he created alarm around him. You got to wonder what alarm was created when Mr. O'Brien initiates a lockdown. You got to wonder what alarm gets created when police start entering the area. So was it Mr. Worley that created the alarm that Mr. O'Brien's talking about, or was it Mr. O'Brien and the police that created that alarm that they're talking about? What's important here is that half hour of video of him walking around the street. A runner goes by. Two young teenage-looking girls with signs for the fireworks stand. He walks into the fireworks stand. A couple of other people in the parking lot. The Burgerville. Nobody acts surprised even. This case is important because the city wants you to convict Mr. Worley of a crime when all he did was carry a weapon. The statute specifically says, in a manner, under circumstances, and at a time and place that warrants alarm for the safety of others. Talking about kind of statutory constructions, how things are written. It's important here. It says, in a manner, under circumstances, and at a time and place. That and is important. It's not or, it's and. The city has to prove to you that he carried it in a manner that warrants alarm. The city has to prove to you that he carried it under circumstances that warrants alarm. And the city has to prove to you that he did it in a time and place that warrants alarm. All three. Not one, not two, all three of them. The city just said to you, the big deal here is the time and place. He's in a huge parking lot. He's not in Big Al's. He's not at some huge public sporting event where there's tens of thousands of people. He's in a parking lot. And the parking lot's really not that busy when you look at the video. In a manner. Carrying it in a manner. There is no different way to carry that and not pose a threat and not cause alarm. All he did was carry it, and we know that open carrying is not illegal. If you find him guilty here, you are following the city's desire to make it open carry illegal, because that's what's going on. It's important. This verdict is important. When you go down and sit with the jury instructions and really take a look at what the law is, I'm not going to tell you that one instruction is more important than the other. The judge has told you that they're all equally important. But look at instruction number 9. Warrants alarm for the safety of others applies only to conduct that poses a threat. Mr. Worley engaged in 0 conduct that actually poses a threat, other than the mere carrying, and the mere carrying is not illegal. It's imperative that you guys find him not guilty. Thank you.
Am I being detained right now, officer?
Let me see your ID.
No, thank you.
What's that?
No, thank you.
No, thank you?
No, thank you.
Okay, why are you saying no, thank you?
I know it's my Fourth Amendment right. I don't have to show you my identification. Okay, so you're not going to answer. Okay. What's your badge number?
1382.
And your name?
Devlin.
Devlin. Yours?
1375.
Name?
Trainer.
You do know that you're required by law to actually give me your name when I
Just
ask.
did.
Really comfortable too. That's one thing I really like about this bag is the comfort level of it. But anyway, so let me move on here and we'll start showing the back here, show the features. First thing first here, we got the front of it.